All right, looks like we have people that have come out of the waiting room and joined us. So good evening, everyone. My name is Tracy Marshall. I serve as the Division Director for FAMLI at the Colorado Department of Labor and Employment. FAMLI is an acronym standing for Family and Medical Leave Insurance, and I want to welcome you to this rulemaking hearing for this division and our program. The time is 5:01 p.m. on Monday, May 15th, 2023. This is a public rulemaking hearing held online with participants listening and speaking by internet and phone. A recording of this hearing will be added to the administrative record for these rules. Thank you all again for joining us. The following division officials are joining me also on today's call. Evan Grimes, our Policy Unit Manager, Mona Carpusas, our Senior Policy Advisor, Erin Bustamante Trinidad, Senior Policy Advisor, Christina Hall, Policy Drafting and Compliance Analyst, and Giovanna Miku, Customer Care Representative and our Spanish interpreter this evening. I'm now going to turn you over to Mona, who can hopefully say her name better than me, and she will take care of you for the remainder of the hearing. Thank you all so much. Mona, we don't have audio for you.
Well, it's Can everyone hear me now? Great, thank you. Good evening, everyone. My name is Mona Carpuzos, and today we will accept testimony for 4 sets of proposed family rules that were published in the Colorado Register as proposed rules on April 25th, 2023. Those proposed rules are amendments to regulations concerning coordination of benefits and reimbursement of advance payments, also known as Citation 7, CCR 1107-4, regulations concerning program integrity, also known as Citation 7, CCR 1107-6, regulations concerning employee job protection, anti-retaliation and anti-interference, also known as Citation 7, CCR 1107-7, and regulations concerning investigations, determinations, and appeals, also known as Citation 7, CCR 1107-8. Anyone may speak on these rules. We will not be taking testimony on other family policy topics that are not part of these proposed rules this evening. For all rules from this division, the notice of public hearing and associated rulemaking documents were filed with the Secretary of State for publication on its website and in the state register, as provided by the Colorado Administrative Procedures Act. The division then posted all rulemaking documents on its website and publicized them to our contact list of stakeholders. For more information on any of these proposed rules from the division, please visit the division's rulemaking page at FAMLI, FAMLI.colorado.gov, and locate the tab labeled Proposed and Adopted Rules. Before we begin, here are some guidelines for the record. In this hearing, the division is accepting oral testimony, as well as written comments through the Zoom chat window. The same administrative record will include all oral testimony, all comments in the chat window, and all written comments submitted outside this hearing. All testimony and comments are reviewed by the same division officials. While you are free to comment or testify by whatever means you prefer, there is no need to repeat points in multiple forms of testimony and comment submission. Written comments may be submitted in various ways. You may email them to the division. You can submit them through the form on our website, or if they're short, you can just type them into the chat window in the Zoom hearing. The comment deadline is tonight, May 15th, 2023 at 11:59 p.m. This hearing is for comments related to the proposed rules. If you have individualized or general family questions that you would like answers to, we would be happy to respond outside this hearing. Email questions to cdli_info@state.co.us so we can route to the right person to give you an individualized response. If you are testifying, please keep your phone on mute until we call your name. For those speaking, when we call on you, please do the following things. Please unmute yourself. Please state your full name, job, and role, and whether you are speaking on behalf of any organization. Start by saying which rule or rule citation you will discuss. Please speak in a clear, slow voice. We may interrupt you to ask you to repeat anything we think may not have been heard or that we think may not be audible on the recording. Please remember that testimony is limited to 5 minutes. I just wanted to stop briefly to tell everyone that we will be able to unmute you if you're having any difficulties, and we probably will unmute you as the hearing is going on once it's your turn to speak. If you wish to remain anonymous, that is your right, and you can say your first name or a fake name, or just describe as much as you are comfortable as to your role or the experience you are here to testify about. We know many of you have put more input on these rules than 5 minutes of speaking can cover. That is why we've been soliciting written comments prior to tonight's hearing, and we'll continue to do so until 11:59 p.m. tonight, May 15th, 2023. Again, if you have more to say than you can cover in 5 minutes of speaking, you can submit the rest as a comment, either by emailing it to cdle_FAMLI_rules, RULES, at state.co.us, or by using our Google form to submit written comments. If you would like to give your name and information for the record, whether you testify or not, or if you are not on the division stakeholder list and would like to be sent notices of proposed rules or other family publications, you can email the division at cdle_FAMLI_info@state.co.us after this hearing, or fill out any of the division RSVP forms on pages linked to our rulemaking page, which again is FAMLI, FAMLI.colorado.gov. Thank you for your interest in and your participation in these important matters of Colorado labor law and policy. Thank you again for taking the time to attend this public hearing and to participate in our rulemaking process. We will now proceed with oral testimony. We will start with those who signed up to testify in advance. Nina DeSalvo.
Hi, can you hear me?
Yes.
Good afternoon, and thank you for your time today. My name is Nina DeSalvo, and I'm an attorney and the policy director with Towards Justice. I would first like to thank CDLE for this process and for accepting both oral and written feedback. Second, I'd like to share some suggestions for improving, first, the investigations, determinations, and appeals rules, and second, the program integrity rules. First, we recommend updating investigations, determinations, and appeals rules 8.2.4 and 8.3.1 to prevent rigid formatting requirements for family complaints from undermining access to justice, particularly for vulnerable workers. A complaint should present a clear statement of why the individual believes that their rights under the family program were violated, but the rules ought not require it to be on a particular form or in a particular format. Adding flexibility to these rules will allow CDLE to support workers who need assistance in filing complaints and prevent technicalities from barring claims. Modifying these rules would also be consistent with the appeals process described later in the rules, which doesn't require filing on a particular form. Second, we recommend modifying Rule 8.6.5 to indicate that where a worker so requests, CDLE shall and must file an agency determination with the clerk of court that has jurisdiction over the parties. Agency filing of these determinations is tremendously useful for workers who are struggling to enforce an agency determination. Agency filing also supports the agency's own authority by increasing the probability that its determinations would be enforced. And it would also be consistent with procedures used by other divisions. For example, the Division of Labor Standards and Statistics is statutorily required to file wage theft determinations with the court at the request of a worker. Also, given the infrequency with which workers will need to enforce family-related determinations in court, a mandatory requirement in this rule 8.6.5 would be unlikely to substantially increase workload for your division. With regard to the program integrity rules, we recommend updating rules 6.3.1 I and K and 6.5.1 I and J to ensure that they don't lead to unfair or inequitable outcomes. As written, those rules would allow automatic collection of benefit overpayments for employees, even where the employee had no idea that their employer or healthcare provider had made a mistake causing an overpayment. So where an employer wage reporting error or a health provider acting outside the scope of their practice leads to a benefit overpayment, there should be some requirement that the employee had knowledge of the error before strapping the employee with repayment obligations. It can be very onerous for workers to repay a benefit overpayment, and few of us review our employer's wage reporting or check our healthcare providers' license compliance practices. These rules, they shouldn't require that level of care. This could mean changing rules 6.3.1 and 6.5.1, or it could mean ensuring that worker knowledge of the cause of the overpayment be added as a factor to be considered in determining whether collection of the overpayment is against equity and good conscience. That's all I have for today. I hope these comments are useful as you improve the family rules, and I thank you again for your time today.
Thank you so much, Nina. We appreciate it. Next, we have Sophie Merriam.
Here we go. Can you guys hear me okay?
Great. I can hear you, Sophie. Thank you so much.
Fantastic. Thank you, guys. Good morning. Good evening, everyone. Good evening, members of the Family Division. My name is Sophie Merriam. It is the evening, and I am a labor policy analyst at the Colorado Fiscal Institute. CFI is a member of the Family Implementation Coalition, along with our partners at 9 to 5 Colorado. And CFI is a statewide nonprofit that works to make Colorado a state where fiscal and tax policies promote equity and widespread economic prosperity. We believe that to continue growing our state's economy, we really need to have economic policies that center the well-being of workers and their families. And this includes ensuring widespread access to benefits such as paid family and medical leave, through ensuring that the oversight and accountability necessary is there to protect the benefits that workers are entitled to. Firstly, CFI would like to appreciate the department's responsiveness during the stakeholdering process to using the 200% of the federal poverty line as part of the quote equity and good conscience standard in the provisions in the proposed rules 7 CCR 11076. 6.2.6b. We strongly support the use of the 200% standard and benchmark because it's a more accurate measure that reflects current economic realities facing Coloradans who earn low incomes. Many economists argue that the official poverty measure of that 100% benchmark is outdated and inaccurate measure. One 2016 survey even shows that across demographic profiles, Americans overestimate how high, think that the government is really setting the bar too low, and Americans are overestimating how high the poverty line should be and how many people should live below it. So this is a much more accurate estimate, considering that we know that this measure is based on a centuries-old number on how much families spent on food 5 decades ago, regardless of the high cost of living now. So we really support the use of that metric the 200% of the federal level. Secondly, regarding continuing violations and fines, we urge the division to build on the accountability that's already established through the fines for violations in order to promote employer compliance. So we appreciate the specification in section 7.51 that violations of CRS 813-3509 will result in a fine of $500, which is consistent with the family statute. However, we urge CDLE to make it clear, as in the already promulgated Family Rule 7 CCR 11073, section 310(3)(b), that, quote, each day such violation continues shall be deemed a separate offense that subjects a non-compliant employer to an additional fine for each day. So this standard for continuing violations is especially important and fully appropriate in this context because we think it falls in line with existing family benefit rules and will ensure compliance to the program rules. And finally, CFI's final comment concerns proposed section 6.52, which would require private plan administrators to send a copy of a benefit overpayment determination letter to the division with the benefit overpayment when the benefit overpayment will total $100 or more. We support this critical accountability provision as it would ensure the division is aware of any overpayment trends, and regardless of whether an investigation is requested directly from a worker or employer, this is a really important information for CDLE in its oversight role. So the department can audit for any concerning patterns in the volume of overpayments from a private plan administrator. However, the $100 threshold we believe is too high, so we urge CDLE to lower this amount to $25, which strikes the right balance for all parties because a benefit overpayment nearing $100 can really make a big difference for workers who are earning low wages, who may struggle to make ends meet and are already experiencing a change in their family or life or health situation that led to a need for family. But we believe we could balance that with a $25 standard, which ensures that CDLE can also provide strong oversight and address any problems in a timely manner without requiring that private plan administrators notify CDLE for truly de minimis payments under that $25. Thank you and appreciate all the work that you guys are doing and happy to stay around for any questions or concerns. Thank you.
Thank you, Sophie. Next, I have Joe Grubb. Joe Grubb. Okay, it appears that Mr. Grubb is not here. I will now move on to, and I apologize if I butcher your name, Kaya Beresford. Kaya or Kaya Beresford. All right. I don't think Kaya is here either.
She's Kaya. Can you raise your hand? There's a few Caitlin L. tones. So if you could raise your hand of which one you are, thank you. Thank you so much.
Good evening. Hang on, let me just get my computer set back up. My name is Dr. Kaya Beresford. I live in Greeley. I am a 9-to-5 member, so I think we're all logging in under Caitlin's name tonight. I was an OBGYN until I injured my wrist and hand at work. I have 2 children, and my baby just had his last day of high school today. And I wanted to comment about some of the proposed program integrity rules. For scenarios when family benefits are determined to have been overpaid, I'm glad that y'all in the division are using equity and good conscience as a lens to decide if the overpayment should be returned. Within this, I do also support the use of the 200% of the federal poverty level. And I agree with Nina, and I think it was, I can't remember if it was Sophie earlier, who were also commenting that the federal poverty level, it is outdated. And with the cost of living skyrocketing in Colorado, it really doesn't give a real sense of a family's financial security. Going above that and considering how well someone is able to cover their basic needs, like, food, shelter, medical costs, et cetera, is much more important. The cost of healthcare is increasingly high, and this puts a major burden on families. I know there are many high deductible healthcare plans out there, and patients might be out several $1,000s for the birth of a child, and then are surprised that their child also gets a separate several $1,000s of copay before they reach their deductible. For scenarios where benefits are overpaid or incorrect because of an employer or a healthcare provider mistake or not being qualified, I also urge the division to add these rules to require consideration if the worker had knowledge. Not everyone is able to access quality healthcare or even know if the provider they're seeing is practicing outside their scope and not able to provide accurate information about their needs and their benefits. And I thank you very much, and I hope you have a good evening.
Thank you, Dr. Beresford. We appreciate your time. Next, I have Brandy Harrison. Okay, Brandy is not here this evening. We do have May15, Marsha, and I'm so sorry if I've made a mistake on the pronunciation there. I would like to introduce our Spanish-speaking interpreter for the evening. Giovanna is here, and Giovanna will be able to assist Mate in answering any, in providing comments.
And same thing, if you're on Caitlin's account, if you could raise your hand so we know which one to account for, that would be great. Giovanna, could you translate that for us to have her raise her hand so that we know which account she's using?
For Kathleen or for
Yeah, so they're logging in on Caitlin Altone's accounts. So we have multiple for her, but we're trying to identify Métis?
Métis?
Yeah. So if she could raise her hand, that will help us know which account she's using.
Hola Maite, ¿puedes levantar la mano para saber cuál es la cuenta que estás usando?
Thank you.
Hola, buenas tardes. Mi nombre es Maite Marcha. Vivo en Fort Collins, Colorado. Soy miembro de 9 to 5. Soy ama de casa y mi familia incluye a mi esposo y mis 2 niñas. Como ama de casa, para mí es muy difícil, como mi esposo y yo batallamos para tomar el tiempo necesario para nuestra salud. Cuando mis niñas o él se enferman, tenemos que procurar de cómo pagaremos nuestra renta y otros costos, ya que el ingreso de mi esposo será menos. Por eso lucho por un programa de licencia familiar y médica pagada para nuestras familias. También como latina es muy difícil aplicar porque en estos instantes, porque la mayoría de las aplicaciones son en inglés y tengo que buscar ayuda en las escuelas para que me puedan traducir adecuadamente, ya que esos documentos son muy importantes. Gracias a la división FAMLI por su trabajo en la construcción de este programa esencial. Mi comentario es para las reglas propuestas sobre investigaciones de determinaciones y apelaciones. El derecho a cuidar de sí mismo y de su familia, mientras recibe una licencia remunerada protegida por el trabajo que FAMLI proporcionará. Es clave para los lugares de trabajo y las comunidades justas. Desafortunadamente sabemos que habrá momentos en que se viole este derecho y que aquellos que son más vulnerables tienen más probabilidades de experimentar estas violaciones. Es por eso que insisto a la división a mejorar la accesibilidad en el proceso de quejas. Esto se puede hacer agregando a las reglas que las personas que no hablen inglés tengan acceso a los documentos y la traducción en su idioma, creando flexibilidad en la forma en que se pueda presentar las quejas a la división. Ser adaptable a las diversas necesidades de comunicación es muy importante para aquellos de nosotros que no aprendimos inglés como primer idioma o que queremos defendernos, pero tenemos barreras para navegar en el proceso de quejas. Le pido a la división que también alargue el tiempo permitido para responder las solicitudes de información de la división cuando un trabajador presenta una queja. Estos trabajadores harán malabarismos en la violación de sus derechos y cambios significativos en la vida, como un nuevo hijo o una condición médica grave. Todos merecemos, gracias en estos momentos, mayor estrés. Además, entiendo que en algunos casos, incluso si la división ha resuelto una queja a favor del trabajador, el trabajador puede tener que acudir a los tribunales para hacer cumplir esa necesidad, esa sentencia en el empleador. El sistema judicial puede ser infalible y es posible que muchos sepan cómo empezar. La división puede apoyar a los trabajadores iniciando el proceso. Por último, agrego a la división por incluir en estas reglas que no compartirán voluntariamente a esto. Al estado migratorio de los trabajadores. El temor de que el estatus migratorio de uno o de un familiar sea usado contraducente puede disuadir a los trabajadores en buscar ayuda por todos los inmigrantes. Son una parte importante de la comunidad de Colorado y la protección ayudará a muchos. Gracias por escucharme.
Muchísimas gracias. Voy a traducir. I will try to translate it. Good afternoon.
Giovanna,
Yeah.
may I interrupt you just briefly? That was a great comment, and we really appreciate Ms. Marcia providing that to us. I want to make sure that we are fair to all of the commentary that she provided to us. And for that reason, I would like it if you could please just reassure her that this has been recorded, and we will make sure to listen to the recording again with an interpreter present, and so that we can ensure that we have the full comment for the record.
Maite, dicen que muchísimas gracias por darnos su comentario y su testimonio, que realmente tienen su solicitud presente y que van a asegurarse de que escuchan a cada detalle de su petición y que verán con todo detalle paso a paso, y muchísimas gracias por su testimonio.
Okay, thank you so much.
Muchas gracias.
Okay, next I have Chris Garcia.
Hello, can you hear me?
Yes, I can. Thank you so much.
Okay. Hi, thank you to the CDLE for allowing me to testify today on something that is so important to me. My name is Chris Garcia. I live in Littleton, Colorado. I'm a 9-to-5 member, and I am a ramp service lead for United Airlines. And my family includes 4 boys, the youngest, which is 2, which you might hear in the background here and there. And so my comment today is going to be on the proposed rules for job protection, and then a comment on the anti-retaliation and anti-interference. So for me personally, the biggest one for me is the job protection. And it's so important when it comes to the family legislation, and that we do have something to protect our jobs, because obviously if we don't have a job to come back to, it's going to be hard for somebody to want to take leave. I know personally, like, I've worked in smaller businesses under 50 employees, and that was one of my biggest interferences and hindrances that I was running into when my mom was battling cancer is I had them basically tell me that they couldn't assure me that my position would be there if I did decide to take the leave to spend some time with my mother. Ultimately, I did end up leaving that job, but that's something that it's like most people don't want to do, especially if you've been trained and you're specialized in a job. All you want to do is get back to work. You just want to be able to take care of your family and work. So having that job protection, I think, would allow more families to be able to do that, to take care of their families, but also know that financially they're not going to be devastated by taking that time to care for a loved one. And then I also wanted to thank you guys on the strong definition on retaliation and not using immigration status as a way to interfere with the access to family. But I do urge the division to revise the rules that include the contract ending, and so that it can only be used to not to reinstate someone to their position if it's in a written contract. So they shouldn't rely on verbal, which could be used to harm workers. And it's also harder to enforce. So if we could have it where it's written. And then I also urge the division to strengthen the rules by defining downsizing and reorganizing as it's done in the federal FMLA, because I feel like the more clarity that workers and employers can have, then the better it will be to ensure that the jobs are protected and workers can advocate for themselves. Thank you for your time.
Thank you so much, Chris. Sarah Montgomery.
Hi, can you hear me okay?
I can hear you.
Great.
Thank you so much.
Hi, my name is Sarah Montgomery. I'm an Assistant Vice President for Paid Family and Medical Leave Implementation at the American Council of Life Insurers. And I wanted to thank the division again for this opportunity to provide some oral testimony in addition to the written comments that we have provided to the division on the proposed rule set. I won't take up too much time since we have submitted a comment letter with details on sections and cross references that we have some concerns about, but just wanted to mention quickly that in the amendments to the Section 4 rules concerning coordination of benefits, the proposed rule 4.2.6 on that prescribes how family medical leave insurance benefits are only reduced by unemployment or workers' compensation benefits is provided in these rules. We are still concerned, our member companies are still concerned that there are still some conflicting provisions within the rules, specifically 4.3.1 and 4.4.1 that send some conflicting recommendations about whether benefits are available while people are on unemployment or workers are collecting benefits under unemployment or workers' compensation insurance. Again, the details are provided in the letter, so we don't have to, I won't go through all of the cross references, but there are a few places where we have concerns about that and would request that the department review the rules again and just clarify when benefits are and are not available under unemployment and workers' compensation programs. In addition, we have one other comment on just, again, some conflicting provisions that could lead to confusion for claimants in the Section 8 rules concerning investigations, determinations, and appeals. We would just note that there are appeals rules covered in Section 8.8 that are duplicative of some of the existing overpayment rules and the adverse claim determination rules in Section 3. So we would ask the department, again, we understand the Section 3 rules are not at issue in this round of rulemaking, but again, to review the Section 8.8 rules in light of Section 3, and then potentially just streamline the provisions in perhaps a future rulemaking round to reduce any confusion for a claimant that they would be potentially unclear about which section of appeals rules apply to their specific situation. Again, thank you so much for this opportunity. I have submitted a letter and I appreciate you allowing us, again, the opportunity to take part in this process. We appreciate it.
Thank you so much, Sarah. Now I do have Caitlin Altone listed. Do we have the actual Caitlin Altone? Okay.
Hi, can you hear me?
I can hear you. Thank you.
Yes, thanks. Well, I've learned a little bit about how the Zoom link sign up works tonight. Thank you. My name is Caitlin Altone. I'm a senior organizer with 9 to 5 Colorado. We're a statewide member-based economic justice organization that centers gender and racial equity. We represent workers throughout the state. I also chair the FAMLI Implementation Coalition, which includes worker and community advocate organizations from across Colorado. And I thank you for the opportunity to provide comment. The coalition will be submitting a joint comment that goes into more detail, but I'll use my time now to highlight a few points in the proposed job protection, anti-retaliation, and interference rules, and also the proposed investigations, determinations, and appeals rules. So in the job protection rules, 9 to 5 supports the proposed definition of retaliation, and we appreciate the removal of the exception that was included in an earlier draft shared with stakeholders. Clearly stating this protection is very important for all Coloradans, especially those who are more at risk for on-the-job discrimination because they hold more vulnerable identities or are marginalized in some way. We also thank the division for including in the rules that immigration status cannot be used to interfere with a worker's access to family. We are also in strong support of the change to allow, to only allow reinstatement to a different job location that does not significantly increase commuting time or distance. This is an important protection as a major change in commute would be detrimental to most people, but especially those relying on public transportation or who transport dependents to care or schooling as part of their commute routine. And for the investigation rules, we urge the division to make some changes that will improve accessibility. These would be explicitly stating that processes will be available in the worker's preferred language, allowing for complaints to be initiated with or without a specific written form, and allowing for complaints to be made anonymously. Unless addressed, each of these points could be a difficult barrier for workers to overcome in order to make a complaint. And accessible complaint procedures are just really important, both for that individual worker who has had their rights potentially violated, but also for the broader Colorado community to discourage repeat violations. So yeah, thank you so much for the opportunity to speak and share comment, and thank you so much for all of the work being done for the FAMLI program.
Thank you, Caitlin. Next up, I have Jared Make.
Hello, were you able to hear me?
I can hear you, Jared. Thank you.
Terrific. Well, good evening, everybody. I'm Jared Make, Vice President of A Better Balance, and I'm based in Denver. We're a national legal advocacy nonprofit that provides technical, legal, and policy support on paid leave programs across the country, including here in Colorado. And I'll be delivering feedback on behalf of A Better Balance. And we appreciate CDLE's stakeholdering work on these rules, and thank you for the opportunity to testify. And my comments tonight will address 11077 and 11078, but I will be submitting written feedback on all sets of rules this evening after the hearing concludes. So first, I'd like to express our strong support, which you also heard from Caitlin just a few moments ago, for CDLE's earlier changes during the initial stakeholdering process to the definition of retaliation in 7 CCR 11077. And we urge CDLE to maintain the current proposed definition of retaliation, which is consistent with the statutory text and doesn't add any exceptions that aren't supported by the law. And this definition and the lack of exceptions also mirror nearly every other state paid family and medical leave program, the federal FMLA, and Colorado labor law. And then next, we'd like to address the proposed rules on reinstatement in 7 CCR 11077, section 7.3. A Better Balance also thanks CDLE for ensuring greater alignment with the FMLA regarding regular and consistent overtime, commuting times, and what constitutes an equivalent position. However, we fully support the recommendations that Chris Garcia shared earlier during this hearing and believe the exceptions to job reinstatement should be strengthened in these two key ways. So first, in section 7.3.2, subsection D, it's important that where the end of employment pursuant to a contract is an exception to reinstatement, that the contract must be written. This is essential to ensure an employee is aware of such terms, and moreover, requirement of a clear written contract will help CDLE to better administer this exception, since it will be much clearer when there is a written contract. And an oral contract shouldn't be sufficient for such an important exception to one's legal rights under FAMLI. And then second, we believe key employee safeguards from the FMLA should be explicitly incorporated to ensure any downsizing or reorganization is truly legitimate pursuant to sections 7.3.2E and 7.3.3A9. This standard is already well established for the federal FMLA, and you can see that in regulations at CFR 825.216A1. And we believe that consistency on this point is in everyone's interests. And then finally, we urge CDLE to lengthen the timeline in section 8.3.4 of the proposed investigation rules, and that's 11078. And, you know, in terms of the timeline that's here, this is what addresses informational or investigatory requests and how long a claimant has to respond. And very strongly believe CDLE should use the same approach that has already been adopted in Colorado by CDLE in section 3.1.4 of the wage protection rules, which uses a period of 35 days rather than 15 days, and further makes it clear that a complaint can be refiled after this period. I mean, we believe that there's really no rationale at all for using a stricter approach on curing information gaps in the context of family investigations than in the existing wage complaint context, especially when family often involves individuals balancing pretty urgent or pressing family, medical, or safety leave needs. And so as I mentioned earlier, we'll be submitting more detailed technical feedback and comments on these points and others later this evening with some accompanying red line drafts to hopefully help illustrate where the points are that we're raising in the rules themselves. And thanks again for your consideration and all of the work on these rules.
Thank you so much, Jared. Now we would invite those who did not sign up in advance to offer testimony. So please raise your hand on Zoom if you would like to speak, and we will unmute you. Do you have anyone else who would like to speak this evening? The raise hand function. I apologize. The raise hand function is on the bottom of the Zoom bar. If you would like to speak, you can still raise your hand. All right. Well, what we will do is go ahead and wait 5 minutes for anyone else to join, and then we will conclude the hearing for this evening.
Can I speak in Spanish?
Yeah, go ahead, Giovanna. That'd be great.
Perfecto. Ahora invitamos a aquellos que no se inscribieron con anterioridad a ofrecer su testimonio. Por favor, levanten la mano en Zoom si desea hablar y les quitaremos el silencio. Espere 5 minutos a que alguien más se incorpore. Luego anuncie el tiempo. Esto concluye la audiencia pública de hoy.
Again, everyone, we have about 2 minutes remaining. If anybody would like to submit a comment, please raise your hand and we will unmute your microphone so you have an opportunity.
Tenemos como 2 minutos si gustan participar. Esta es la oportunidad que levanten su mano y le quitaremos el silencio.
All right, everyone. Well, thank you all so much for your time and consideration. The time is 5:54 p.m. and this concludes today's public hearing. Good evening, everybody.